ER 588. This case is set for sentencing today. It's the State of Ohio versus Kyle Starkey. The defendant's been convicted of the following charges as he was found guilty by a jury after a jury trial. That verdict came back on July 1st of 2016. That was for 9 counts. Counts 1, 2, and 3, convictions of kidnapping, all felonies of the first degree. Counts 4 and 5, convictions of rape, also felonies of the first degree. Counts 6 and 7, both counts of felonious assault, felonies of the second degree. Count 8, an intimidation of a victim or witness, that's a felony of the third degree. And count 9, domestic violence, a misdemeanor of the first degree. The first 3 counts of kidnapping all included an additional finding by the jury that the defendant did not release the victim in a safe place unharmed. The State of Ohio is present, represented by County Prosecutor Nicholas Irochi and Chief Assistant Prosecutor Cecilia Cooper. The defendant, Kyle Starkey, is present, and he's represented by his attorney, David Perdue. All right, the court had an opportunity to address in chambers the issues of merger. So in regards to merger, the court finds that count 1 of kidnapping does not merge for purposes of sentencing because the evidence showed that this act was done with a separate animus than the other crimes, specifically to leave the area of Worcester, Ohio, to prevent the victim's mother or others who may see the victim from seeing her bruises and other physical marks, so that the defendant's crimes of rape and felonious assault occurring in Worcester would not be discovered. This count of kidnapping is not part of the rape or felonious assault counts, and harm from this kidnapping is separate and identifiable from the other crimes. The court finds that count 2 of kidnapping does merge, pursuant to the Ohio Revised Code and current Ohio Supreme Court case law, with count 7 of felonious assault, for purposes of final conviction and sentence. The court reasons that the evidence showed that the animus was for the purpose of terrorizing or inflicting serious physical harm to the victim in the count of kidnapping and in the count of felonious assault. A defendant knowingly caused or attempted to cause physical harm, both actions with the use of a knife, a deadly weapon. The State of Ohio, as addressed in chambers, has elected to proceed on count 2. That's the kidnapping charge, correct?
That is correct.
And therefore, a final conviction and sentence will be entered on count 2. The court finds that count 3 of kidnapping does merge pursuant to the Ohio Revised Code and current Ohio Supreme Court case law with count 5 of rape for purposes of final conviction and sentence. The court reasons that the evidence showed that the animus to commit the kidnapping occurring in Geneva on the Lake was committed to facilitate the offense of rape to engage in sexual activity against the victim's will in Geneva on the Lake. So there was not a separate animus on these 2 offenses. The State of Ohio has elected to proceed on count 5. That's the rape count, correct?
That is correct.
And therefore, a final conviction and sentence will be entered on count 5. The court finds that count 4 of rape does not merge for purposes of sentencing with any other crime because evidence showed that this rape occurred in Worcester, Wayne County, and involved a different location, time, and sexual conduct than the other rape. This court finds that the harm that resulted from this rape count is separate and identifiable from any other crime based on the evidence. The court finds that count 9, domestic violence, does merge for purposes of sentencing with felonious assault and count 6 for purposes of final conviction and sentence. However, count 6 of felonious assault does not merge for purposes of sentencing with any other crime besides the domestic violence. The evidence showed the harm involved in this felonious assault was separate and identifiable from any other convictions pursuant to State versus Ruff, specifically that the victim was choked. The state of Ohio has elected to proceed on count 6, correct?
That is correct.
And therefore a final conviction and sentence will be entered on count 6. The court finds that count 8, intimidation, does not merge for purposes of sentencing with any other conviction, because as supported by the evidence, the threat of harm is for the future, and such harm could be to either the victim or her mother, and therefore is separate and identifiable pursuant to Ruff. The court further notifies the defendant that the domestic violence conviction is an enhanceable offense, so that if you were ever to get another domestic violence charge in the future, it could be charged as a felony. If there's anything to say personally or through counsel or both as to why judgment and sentence should not now be pronounced or in mitigation of sentence. Mr. Perdue.
Yes, Your Honor. My client does not wish to address the court at this time, but I would in mitigation.
All right, thank you. Mr. Perdue, go ahead.
Mr. As we respect we don't agree, but we respect the jury verdict, obviously, in this case. My client, as the testimony elicited, had a rough childhood. He was in several different foster homes. Saw his dad commit suicide at the age of 9 years old, and has had a rough time all the way up till now. We would ask, Your Honor, based upon the facts and based upon his lifetime experiences, going to 11 different schools as was brought out, and the life that he's had, we would ask the court to take lenience on him and give him the minimum sentence, which would be 6 years. Thank you, Your Honor.
Thank you, Mr. Perdue. And Mr. Starkey, you do not wish to make a statement, is that correct?
Your Honor, I will be brief. As the court is well aware, the state has submitted a 12-page memorandum, sentencing memorandum, that I'm not going to reiterate in open court today, but I will highlight some things based on the factors, the sentencing factors, whether the first factor, whether the offender's conduct is more serious. The court did hear the testimony and evidence at trial. The defendant raped his victim in one of the most humiliating manners possible. He also prolonged her suffering by requiring her to remain with him for 2 days. The physical, visible marks left on her 3 days after the brutality is quite evident, and it does go to the more serious factor. In this case, the victim suffered immensely, both physically and emotionally. She has provided to the court a victim impact statement, which Ms. Cooper will read in open court this morning. The relationship between the defendant and the victim, in that they were live-in boyfriend and girlfriend, facilitated the offenses. The defendant could not have committed these offenses for which he stands convicted had it not been for that residential relationship between them. The defendant in 2004 was adjudicated delinquent for aggravated assault and gross sexual imposition. In 2012, he was convicted of unlawful restraint. He's now a convicted rapist, and we would ask or suggest to the court, as his conduct escalates, the risk of recidivism is high. Your Honor, we did provide a recommendation in the sentencing memorandum with the merger issues slightly changing this morning after consultation with the court in chambers and with the court just addressed now in open court. We would like to modify slightly our sentence recommendation. The state would recommend a 10-year consecutive sentence on count 1. Count 2, a 10-year consecutive sentence. Count 4, a 10-year consecutive sentence. Count 5, a 10-year consecutive sentence. Count 6, a 7-year consecutive sentence, and count 8, a 3-year consecutive sentence. We do believe, Your Honor, that this defendant's criminal conduct justifies consecutive sentences. Concurrent sentences would demean the seriousness of his conduct. Further, the harm caused by 2 or more of these offenses was so grave or unusual that no single prison term for any of the offenses adequately reflects the seriousness of the crimes committed. I would ask now Ms. Cooper to read the victim impact statement.
And the total amount of years that you will request?
Total amount of years, 50 years.
50 years.
We understand that the range, based on the court's determination of merger, is between 6 years and 55 years. So the state is recommending 50 years total.
Thank you, Mr. Ehrlich. Ms. Cooper.
Thank you. The victim has written to court. After Kyle maliciously assaulted me, kidnapped me, and raped me, I have lived in complete fear. My life quickly changed. I learned what it's like to be afraid for my life, feel fully helpless, trapped, and degraded, to feel less than a human being. The way he treated me made me paralyzed in fear and feel like nothing but a sex slave for his personal satisfaction. Only a monster would hold someone against their will and force them to do embarrassing, disgusting, and painful things. He completely traumatized and violated my body. I wanted a new body. I didn't want to look at mine or own it anymore. I didn't want the same body that Kyle violated. I've never been so captured by terror in my life. I know Kyle wouldn't kill me on August 7th, 2013, just like he would have killed me on August 7th, 2013, just like he threatened. I still, to this day, almost 3 years later, worry about him hunting me down and killing me when he's released from jail. After he horrifically assaulted me, I was afraid of everyone, even people I've known my whole life. My mind changed. I was worried anyone could hurt me at any moment. I felt like because I never knew what anyone was thinking, they could attack me and overpower me like Kyle did. Kyle made me feel so defenseless and helpless. At that point, I felt like anyone could kill me at any time because I saw how easily Kyle overpowered me. He had complete control over me and could kill me if he wanted to. And if I didn't listen to everything he said, I was forced to do things I wouldn't even watch in a movie. I had to paint my bedroom walls a different color because I couldn't stand looking at the way they were on August 7th and 8th, 2013. I burned my bed and got a new one because Kyle beat me so bad my bed was covered in blood. Same with the couch in my bedroom. It was covered in blood and I got rid of it and I got a new one. I couldn't stand being in my own bedroom because it looked the way it did the day Kyle attacked me and raped me before we changed everything. I couldn't sleep at night because I was scared to death that Kyle would come back to my house and murder me and my mom. I was even too afraid to tell the police. I felt so helpless and defeated. I felt like no one in the world could help me, not even the police. It's the worst feeling in the world to feel like I have no control over whether I live or not, whether my life continues or is ended so suddenly. Every little noise I've heard at my house, I worry that it's Kyle breaking in to kill me. I couldn't go in public by myself. I couldn't go on my own front porch or in the front yard. I wouldn't shower unless my mom was home because I didn't want to be showering naked and caught off guard. No matter how hot it was outside, I would drive with my windows up because I was worried I would be stopped at a stoplight and Kyle would reach in my car and kill me. I had 2 doors on my car that couldn't be fixed, so it was either they were never locked or were permanently locked. I had them permanently locked so Kyle couldn't get in my car if I drove anywhere. I literally lived in complete fear. I felt like my life's fate was out of my control and Kyle had all the power. He changed me personally. He changed my personality and took all the security and safety out of my hands. I was never planning on reporting this because I knew Kyle would still kill me. Since the other incident, and I knew he remained in jail, I felt safe enough to report it. I have feared for my life ever since this happened, until he went to jail. I still worry that when he gets out of jail, he will still find me and kill me. My life has improved again since I've known he's in jail. I finally started dating again, and I've got engaged. I finally started going to the grocery store by myself. I began to gain control over my life back. I can't stand thinking about what will happen when he's released. In the end, Kyle took something from me that I'll never get back, my innocence and dignity.
Thank you, Ms. Cooper. And the victim, I understand, is present?
She is, Your Honor.
Okay, and would you like to make any additional statement?
No, Your Honor.
All right, thank you. All right, the court received and read the victim impact statement. It was through letter form that was read by Ms. Cooper. The court finds no good and sufficient cause has been shown as to why a judgment and sentence should not now be pronounced, and the court will pronounce the sentence. The court is familiar with the facts and circumstances of these convictions due to the 4-day jury trial in this matter. The courts considered the purposes and principles of these sentencing statutes, as the overriding purposes are to punish the offenders and to protect the public from future crime. The courts considered both recidivism and seriousness factors as well. In regards to recidivism factors, the defendant has a prior criminal record, a history of criminal convictions, both adult and juvenile, which include assault, domestic violence, and gross sexual imposition at the juvenile level, and at the adult level, an unlawful restraint conviction. These convictions show the defendant's propensity for violence. There is no evidence of remorse here. The defendant has not made a statement. Many of these convictions, namely the kidnappings and rapes, are the highest level of felony with presumptions for prison, some of which carry mandatory time. In regards to seriousness factors, the victim suffered serious physical and psychological harm due to the actions of the defendant. The court heard testimony of the victim and read and heard her victim impact statement. The defendant's relationship with the victim facilitated the offense, or these offenses, as the victim and the defendant were in a relationship for a period of months prior to these crimes and lived with one another. These are violent crimes which occurred. Bruising and physical marks on the victim's body provide further evidence of the severity of these crimes. The court has listened to both sides in regards to sentencing recommendations. The court finds that community control would demean the seriousness of the conduct in this case and its impact upon the victim, and would not adequately protect the public. In addition, the rape counts in this case have mandatory prison time required as the punishment. Therefore, a sentence of imprisonment is commensurate with the seriousness of the defendant's conduct, and a prison sentence does not place an unnecessary burden on the state. In regards to the convictions of rape, I have a form entitled Explanation of Duties to Register as a Sex Offender. Mr. Starkey, have you read and have you discussed with your counsel this sheet entitled Explanation of Duties to Register as a Sex Offender?
Yes, I have that.
All right. And has your attorney answered any questions that you may have?
Yes.
All I'm going to read this form to you as well, and then I'm going to ask if you understand it, and then I'm going to ask that you sign it, okay? You've been convicted of or pleaded guilty to a sexually oriented offense as defined in Ohio Revised Code 2950.01. And you are one of the following, and I have checked here, a Tier 3 sex offender registrant. You are required to register in person with the sheriff of the county in which you establish residency within 3 days of coming into that county, or if temporarily domiciled for more than 3 days, you are also required to register in person with the sheriff of the county in which you establish a place of education immediately upon coming into that county. If you establish a place of education in another state but maintain a residence or temporary domicile here, you are also required to register in person with the sheriff or other appropriate official in that other state immediately upon coming into that state. You are also required to register in person with the sheriff of the county in which you establish a place of employment if you have been employed for more than 3 days or for an aggregate of 14 days in a calendar year. If you establish a place of employment in another state but maintain a residence or temporary domicile here, you are also required to register in person with the sheriff or other appropriate official in that other state if you have been employed for more than 3 days or for an aggregate of 14 days in a calendar year. Employment includes volunteer services. You are required to provide to the sheriff temporary lodging information, including address and length of stay if your absence will be for 7 days or more. After the date of initial registration, you are required to periodically verify your residence address, place of employment, and/or place of education in person at the county sheriff's office no earlier than 10 days prior to your verification date. If you change residence address, place of employment, and/or place of education, you shall provide written notice of that change to the sheriff with whom you most recently registered and to the sheriff in the county in which you intend to reside, or establish a place of employment and/or place of education at least 20 days prior to any change and no later than 3 days after change of employment. If the residence address change is not to a fixed address, you shall include a detailed description of the place or places you intend to stay, and no later than the end of the first business immediately following the day you obtain a fixed address, you must register with the sheriff that fixed address. You shall provide written notice within 3 days of any change in vehicle information, email addresses, internet identifiers, or telephone numbers registered to or used by you to the sheriff with whom you have most recently registered. Depending upon your designation, you are required to comply with all of the above described requirements for the following period of time and frequency. And then we have checked here Tier 3 for your lifetime with in-person verification every 90 days. Failure to register, failure to verify residence at the specified times, or failure to provide notice of a change in residence, address, or other required information as described above will result in criminal prosecution. So do you understand your duties, Mr. Starkey?
I do.
All right. And then I'm going to, at this time, ask you to sign this form. and hereby ordered that the defendant will be sentenced to a stated term of the following: 5 years in prison under count 1, that's kidnapping, which is not a mandatory term. 5 years in prison under count 2, that's kidnapping, which is not a mandatory term. 10 years in prison under count 4, that's rape, which is a mandatory term. 10 years in prison under count 5, that's rape, which is a mandatory term. 3 years in prison under count 6, that's felonious assault, which is not a mandatory term. 2 years in prison under count 8, that's intimidation, which is not a mandatory term. All terms are ordered to run consecutive to one another for a total of 35 years. The court has decided that the defendant shall serve prison terms consecutively pursuant to Revised Code 2929.14, and that consecutive sentences are necessary to protect the public from future crime and to punish the defendant. And that consecutive sentences will not be disproportionate to the seriousness of the defendant's conduct and to the danger the defendant poses to the public. The court further finds the following: at least 2 of the multiple offenses were committed as part of 1 or more courses of conduct throughout a 2-day time period in Wayne and Ashtabula counties with a victim who was his girlfriend and with whom he lived. And the harm caused by 2 or more of the multiple offenses so committed was so great or unusual that no single prison term for any of the offenses committed as part of any of the courses of conduct adequately reflect the seriousness of the defendant's conduct, as there was more than 1 rape, and then the defendant assaulted the victim, as evidenced by photos of her beaten and bruised, done by use of threat or force. The defendant's history of criminal conduct demonstrates that consecutive sentences are necessary to protect the public from future crime by the defendant. This is based upon the defendant's past juvenile and adult criminal history and the defendant's propensity for violence. The defendant must pay court costs which judgment is rendered and execution may issue. Credit for time served on these charges is 258 days, and this amount will be noted in the judgment entry. After you are released from prison, you will have a period of post-release control for 5 years. If you violate a post-release control sanction, any 1 or more of the following may result. The parole board may impose a more restrictive post-release control sanction, may increase the duration of the post-release control subject to a specified maximum, may impose a prison term which cannot exceed 9 months, and the maximum cumulative prison term so imposed for all violations during a period of post-release control cannot exceed 1/2 of the stated prison term originally imposed upon you. If the violation of the sanction is a felony, you may be prosecuted, and in addition to any sentence for the new felony, the court may impose a prison term which may be served consecutively with the prison term in this case. You shall be credited with any additional prison time imposed by the parole board for the same violation. While on post-release control, additional periods of time imposed by a court for a felony or by the parole board for violations are part of the sentence in this case. As part of any post-release control, you must comply with any drug or alcohol treatment and/or monitoring. A portion of this sentence is mandatory and the remainder is not. 20 years is mandatory. The remaining 15 is not, for the total of 35. So I'm notifying you that you may be eligible to earn days of credit to reduce the prison sentence for each completed month of productive participation in educational or employment programs or circumstances specified in Revised Code 2967.193, and that's on any non-mandatory portion of your sentence. These credits are not awarded automatically, and they have to be earned in a certain manner. Your sentence could be reduced by up to 8% for available credits if you were able to earn those credits that may be available to you. Under federal law, any person convicted of a felony can never lawfully possess a firearm. If a convicted felon is ever found with a firearm, even one belonging to someone else, that person will be prosecuted by federal authorities and subject to imprisonment for several years. The defendant's been sentenced to a prison term. Therefore, it is ordered that the defendant shall submit to a DNA specimen collection procedure administered by the Director of Rehabilitation and Correction or the Chief Administrative Officer of the jail or other detention facility to which the defendant is serving the term of imprisonment, and that's in regards to the registration as a sex offender. All right, Mr. Starkey, I'm going to notify you of your appellate rights since your case was tried to a jury and you were convicted by that jury. You have, go ahead.
Go ahead, Your Honor, sorry.
All right, it's all right.
Thank you, Your Honor.
Okay. You have a right to appeal. You will have a period of 30 days from today's date to file a notice of appeal. You have a right to appeal without cost if you are unable to write to documents necessary to appeal, including a transcript, which will be provided to you without cost if you are unable to pay for such documents. You have a right to have a notice of appeal timely filed on your behalf without the payment of a filing fee. Mr. Starkey, would you like to have appellate counsel appointed for you?
I think that would.
So the court will order that the Court of Appeals will select and appoint an attorney that will prosecute your appeal for you. And they maintain a list of attorneys that specialize in appellate work, so we will have that taken care of for you. Any bond that's not been previously terminated will be terminated in this case, and you'll be relieved from obligations of any bond. I'm going to order that a post-sentence investigation report be completed in this case. And at this time, the defendant will be remanded to the Ashtabula County Sheriff's Department to be transported to the designated correctional